Good morning, dear students. I welcome you all for today's topic. Our today's topic is professional misconduct. Professional misconduct, we have had an introduction about professional misconduct. Today we will see that who can do a professional misconduct. What are the different illustrations for professional misconduct? Who can initiate the disciplinary proceedings like State Bar Council and Bar Council of India? What are the powers for disciplinary committee? If there is an order given by disciplinary committee, what can be the remedies against that order? That can be review, that can be appeal, and that can be an appeal to the Supreme Court. So this is the line or table of content which we will be discussing in today's lecture. The first thing is what we will be see that what is the professional misconduct. Professional misconduct, as we already seen, that it is a conduct which is also a behavior in a good manner. Section 35 of our Advocates Act has defined it. Before going to its definition, let me give you a basic a definition which is also given in Blacklaw's dictionary. I read and then I'll explain it to you. It says, a transgression of some established and defined rule of action, a forbidden act, a dereliction of duty, an unlawful behavior, a willful in character, improper or wrong behavior. It can be synonymized with misdemeanor, impropriety, mismanagement, offense, but it can be, it should not be negligent or careless behavior. So let's understand, misconduct is anonym to conduct. Conduct is what? Conduct is a behavior with good manners and treatment which is shown to others. Misconduct represents that you are misbehaving with others, and when it is by a professional, it can be seen or it can be known as professional misconduct. We have a case, State of Punjab versus Ram Singh. In this case, professional misconduct has defined by a professional by Supreme Court. The Supreme Court held that, and I quote, misconduct may involve moral turpitude. It must be misproper or wrong behavior, unlawful behavior, willful in character, and a forbidden act, which established and defined rule of action or code of conduct, but mere error of judgment. Mind the line, it says, but mere error of judgment, carelessness, or negligence in performance of duty, the act complained of bears forbidden quality of character. So it says that it should be a moral turpitude, it should be a misproper and a wrong behavior, but mere error of judgment, when a professional cannot judge that what is right and wrong, cannot be called as professional misconduct. The next thing is, an advocate is bound to conduct himself or herself in a manner befitting the high and an honorable legal profession. We all know that law is one of the noble profession, and the professional has to accompany all the duties which has been decided and given to him. The legal profession, being a noble and the highest profession, has some traditions which has to be followed by all the advocates. An advocate is expected, see, there is a high expectation for that person to uphold those traditions which he must comply with the conduct of professional ethics and etiquettes which are laid down by Bar Council of India. We all have section 35 of Advocates Act, which says an advocate may be punished for professional misconduct. See, how we can, this section is not specifically talk about there should be a punishment, what can be professional conduct. I read this section, it says, the Advocates Act makes it clear that an advocate may be punished for the professional or other misconduct. The misconduct or professional misconduct is nowhere defined. It's not given by section 35, but section 35 empowers the Bar Council and the State Bar Council that if there is a proven professional misconduct, then both of the councils has a responsibility, has a right to punish that particular person. Now, next thing is how we can judge that whether this particular act is a professional misconduct or not. There is a two-test theory given. What is this two-test theory? And it is given in the case, that is in the matter of an advocate AIR 1935 RALG 33. This has been held, and I read, the first test is the misconduct is such that he must be regarded as unworthy to remain a member of the honorable profession. The second one is the misconduct is such that he must be regarded as unfit to be entrusted with the responsible duties that an advocate is called upon to perform. So which kind of misconduct the person has done, how it can be a professional misconduct? The first one is that the person who has done become an unworthy person to become to be in this particular honorable profession. The second one is now he is regarded as unfit. That means he cannot be shown in his professional duties properly. So this is the introductory part, where professional misconduct is the conduct occurring otherwise than in the connection with the practice of law that would justify a finding that its preparation is not of good fame and character, or he is not fit and proper person to remain in the role of legal practitioners. The next thing is, okay, after getting the definition part, we have to understand that what kind of behavior can be known as professional conduct. We had two-test theory, we had the introduction. Now let's understand, let's have some of the examples, some of the illustrations for professional misconduct. The first one is if the professional is discourteous behavior towards the bench in the court. That means your behavior is not courtesyful, your behavior is misbehavior towards the bench in the court. The first example. The second one is use of bad words or epithets or disrespectful, derogatory or threatening language in the court. See, your words matters the most. You are a person who is having full of professional knowledge. So if an advocate is using bad language, if he is using derogatory, disrespectful or threatening language in the court, it is a professional misconduct. The third one is exhibiting ill treatment which has the effect of overbearing the court. See, you cannot have an ill treatment. That person who's sitting next, who's sitting in front of you is going to give justice to your client. So that ill temper or ill treatment to the court is another behavior which is professional misconduct. The next one is involving in moral turpitude. If an advocate is involved in moral turpitude, then but for sure that is a professional misconduct. The next one is defraud or cheating the party. Your client is important. If you defraud or cheat the party, if your client you are cheating, professional misconduct. The next one is failing to file a case after accepting a brief and fee plus expenses. See, your duty is to take the case, accept the brief, file the case, fight the case. If you are not, professional misconduct. The last one is engaging in a business of profit making. This is also, and there was a lot more discussion on this, that if an advocate is engaged in a business of profit making, I am so sorry, this is one of the professional misconduct. The next thing which is important, functions of a state bar council. See, the person who has enrolled in state bar council role is the responsibility of state bar council. Now you should have a professional duty towards that bar council. So there is a section 35 which talks about that you may get punishment by the state bar council or by the bar council of India. So here is a procedure and initiation. There is a power behind, with the state bar council, how you can get punishment, how can a person who has done wrong can get punishment. So section 35 is important for us, which says that there are state bar councils in each state. There is a procedure. The procedure is, the first one is receiving a complaint or otherwise. See, even the state bar council, if has a reason to believe that an advocate is guilty, can take a suo motu action. Second, they can have a procedure, they can have an initiation after receiving a complaint. So both the process, both the initiation process can be there. After receiving a complaint, a disciplinary committee will be will be formed, will be framed by State Bar Council, and they will fix a date of hearing. And for this date of hearing, the notice for the same will be given to the advocate and advocate general of the state. Then why there is a notice and why there is a hearing? Because they want to give an opportunity of audio altum partem. After an opportunity of audio altum partem, there will be an order, there will be a judgment by the disciplinary committee. So this is the process. The process is first receiving of complaint or suo motu action. The second one is there should be a disciplinary committee fixed, and they should fix a date for the hearing of the case and shall cause a notice thereof to be given to the advocate concerned and to the advocate general of the state. The disciplinary committee of the State Bar Council, after giving the advocate concerned and advocate general the opportunity of being heard, then they can go to the judgment. The judgment or the power, what could be the judgment? The judgment could be the first if that complaint is baseless or the complaint is disproved. Then the first one is dismiss the complaint. The second one is reprimand the advocate. We know that they suspend, it's called reprimand. They can put a limitation for not having practice for this particular time period. So that's called reprimand. The third one is even suspend the advocate from practice for such a period as it may deem fit. This is reprimand. Remove the name of the advocate from state roll. That is a heinous punishment, that they can also remove the name of the advocate from the state roll. The one of the right which advocate has, that right to practice, can be seized by this particular punishment. Whereas an advocate is suspended from practice in the clause C of subsection 3, he shall during the period of suspension be debarred from the practicing in any court or before any authority or person in India. In the suspension, that clause is there. The next one is functions of DCI. See, State Bar Council, after receiving the complaint from any other person, the aggrieved party or suo motu, is having that particular responsibility, power, but this power for punishing professional misconduct is also lie with BCI. How Bar Council of India takes it? Section 36 is very important for us. Section 36 of Advocates Act simply says, where on receipt of a complaint or otherwise means suo motu action, the Bar Council for India has a reason to believe that an advocate whose name is not entered on any state roll has been guilty of professional misconduct. See, what is important here is, if advocate's name is on the state roll, then that is the responsibility of the State Bar Council. But if the advocate's name is not on any state roll, then there is this, that BCI can take an action against it, and the advocate is found guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. Then BCI and its disciplinary committee has all the powers to see the matter. The second one is, notwithstanding anything contained in this chapter, the disciplinary committee of the Bar Council of India may, either of its own motion or on a report by any State Bar Council, or an application made to it by any person interested, withdraw any inquiry before itself, any proceedings for the disciplinary action against any advocate pending before the disciplinary committee of any State Bar Council and dispose of the same. See, the next process which is there in the 36 is, if any proceeding of disciplinary committee is pending before state road, but BCI think that this particular case should be judged or seen by the disciplinary committee of BCI, then they can call off that particular case and its proceedings to the disciplinary committee of Bar Council of India. The third one is, the disciplinary committee of the Bar Council of India, while disposing in any case under this particular section, shall observe the procedure which is laid down in section 30, which is also taken by State Bar Council, in reference to the Advocate General in that section, being construed as a reference to the Advocate General of India. So in State Bar Council, Advocate General of that state particular will see, but in the case of BCI, Advocate General of India will represent. Now this is the second one, that how they can dispose the disciplinary, proceedings. Section 226B. We will talk about punishment in the later part. The disciplinary committee of a state bar council shall dispose of the complaint received by it under section 35, but here BCI has to dispose of that particular under 36B. Within 1 year of the date of receiving the complaint, there should be a disposal of disciplinary proceedings. Then the next is punishment. The punishments are the same, which we already discussed in the last part. What was the punishment? Dismissal, reprimand, suspension, and removal. The same is with BCI also. It's the same. State Bar Council disciplinary action under section 30. The same punishment BCI can also give. The next important thing which is important for us is powers of disciplinary committee under Advocates Act. See, we talked about the disciplinary committee of State Bar Council. We talked about the disciplinary committee of PCI. Now, what is this disciplinary committee and what are the different powers this disciplinary committee has? So the first thing is the composition. The disciplinary committee should be composite by either a State Bar Council, or if it is, then BCI. How it has been constituted? The Bar Council shall constitute one or the more disciplinary committee, each of which shall consist of 3 members. 2 should be elected by the council from its members, and please avoid this. This is from its members, and others should be from advocates with at least 10 years of experience. So BCI is making the disciplinary committee under Advocates Act, and it gives the power to the State Bar Council to choose 2 members from its own members, those who've been selected in the State Bar Council, and 1 normal advocate, but the normal advocate should have at least 10 years of experience. The next thing is transaction of business. The section 9 clause 1 says and talks about the disciplinary committee constituted under section 9 shall meet at such time and place and shall observe such rules and procedures in regard to the transaction of business at the meetings are prescribed in the section 10A clause 5. What 10A clause 5 says? Disciplinary commission should meet for the cases, proper notice should be issued, proper meeting should be there, meeting ka place should be decided, properly place should be decided. So this is known as transaction of business. Now the powers of disciplinary committee. The powers of disciplinary committee is very important. The disciplinary committee of the Bar Council shall have the same power which are vested for the civil court. That means the disciplinary committee and its members has the same power as the judges of the civil court has. That means they can summon and enforce attendance. They'll be requiring discovery and production of the documents. They can receive any evidence on affidavit. They can examine the witness and documents. They can have any other matter which are prescribed. So you can see all these powers are with the civil court. So the same powers even with the disciplinary committee has, provided there is a proviso that no such disciplinary committee shall have the right to require the attendance of any person which is there in the power. For example, power means any presiding officer of a court except with the previous sanction of the High Court or with such court is subordinate, or any officer of a revenue court except with the previous sanction of the state court. So this is one of the proviso which is there with the disciplinary committee. This is one of the provision. Then the next one is remedies against the order of punishment. What are the remedies there for the action of the disciplinary committee? There is this specific 3 remedies are available. The first one is review, the second one is appeal, and the third one is appeal to the Supreme Court. The first one is review. Yes, section 44 of the Advocates Act simply says that within 60 days of this particular order, the Bar Council or the State Bar Council, they can talk or they can call for the review of its judgment. Section 48 AA of BCI power, BCI gets the power or any of its committee except disciplinary committee. Let me read this section for you. It says, Section 44 of the Advocates Act provides that the disciplinary committee of a bar council may of its own motion or otherwise review any order within 60 days of the date of the order passed by it under this chapter. However, no such order of review of the disciplinary committee of the State Bar Council shall have effect unless it has been approved by the Bar Council of India. What section 48AA says? It says Bar Council of India or any of its committee other than the disciplinary committee may on its motion or otherwise review any order within 60 days of the date of that order passed it under the Advocates Act. So this talks about for the council, State Bar Council. This talks about for the order of the BCI. Then the next process which is important is the appeal. The appeal is in the two ways. The first is appeal to the BCI. Appeal to the BCI from the orders of the State Bar Council, disciplinary committee. So section 37 is important for us. What section 37 says? Section 37 says that any person aggrieved by an order of any person, it's not only the complainant or the respondent, it's both the parties. By the disciplinary committee of the State Bar Council shall communicate the order to the parties if the Bar Council of India does not approve it. The disciplinary committee of the State Bar Council shall make its order dismissing the application and inform the parties. So this is also within 60 days and BCI will approve or disapprove this particular appeal. If approved, then again the disciplinary committee proceedings of BCI will go. If disapproved, then this will be communicated to the State Bar Council and to the aggrieved party. The next one is appeal to the Supreme Court. See, section 38 says appeal to the Supreme Court to the judgment or of the judgment of the BCI disciplinary committee. Here, section 37 for the State Bar Council Disciplinary Committee. Here, this one is the orders passed by the Disciplinary Committee of the BCI. It says, and I quote, excuse me, section 38 says, any person aggrieved by an order made by the Disciplinary Committee of the Bar Council of India under section 36 or 37 or the Advocate General of India, Attorney General of India and Advocate General of the state concerned, as the case may be, within 60 days of the which the order is communicated to him, prefer an appeal to the Supreme Court, and the Supreme Court may pass such order, including an order varying the punishment awarded by the Disciplinary Committee of the Bar Council of India thereon as it deems fit. However, no order of the Disciplinary Committee of the Bar Council of India shall be varied by the Supreme Court as so that prejudicially affect a person aggrieved without giving him an opportunity or a reasonable opportunity of being heard. So this is relevant. It simply talks that Supreme Court can take any action, can vary the judgment, but the variation of the judgment should be with the reasonable opportunity of being heard. Then the last part of this is the conclusion. See, we have to understand that every misconduct is not a professional conduct, but it should be an intentional misconduct, and it should be within the capacity of the professionalism. The next one is the State Bar Council Disciplinary Committee and Bar Council Disciplinary Committee has the same power to see the complaint in their own jurisdiction. Disciplinary Committee can pass the order. The first one is the rejection or the removal of the application. It can suspend the person, it can reprimand the person, and the last one is it can even remove the name of the person from the state role. The appeal against the order of the disciplinary committee can be filed, there can be review, there can be appeal to the BCI disciplinary committee, and appeal to the Supreme Court. Professional misconduct is an act done by a professional under his professional capacity and harm his or her professional attitude. We all have to understand that professional misconduct is not a simple act. It is an act which has intentionally done by a professional while doing his or her professional duties, while delivering his duties, and that act should cause a harm to his professional attitude and to him. With this is all from my side. Thank you so much. If you have any queries, please feel free to ask.